Hello and welcome to another legal talk right here on eRadio with Hahn and Hahn attorneys. My name is Ian, and today I'm joined by Olebogeng Mangena from Hahn and Hahn attorneys. Our topic today is one that a lot of listeners have asked us about. It's something that happens all too frequently, and it's a bit of a scary thought, isn't it? The sheriff at the door, and he wants to take your furniture or write up your stuff to cover your debts. So we're talking about that today. Olebogeng, first of all, welcome back to Legal Talk. I hope you're well.
Thank you. I'm well. Thanks, man. How are you?
Fantastic, thank you. So,
great.
Olebogeng, what should I do when the sheriff is at the door and he wants to take the furniture, but the furniture he wants to take is not mine?
What I want to firstly say is that in terms of our law, the sheriffs are empowered and allowed by the Act and the rules of the court to attach and in some circumstances immediately remove the goods at the specified address mentioned in the warrant of execution, irrespective of whether such goods belong to the judgment debtor, meaning the person who the sheriff has been instructed to execute against. So in that case, the affected person or the sheriff himself can bring an application or institute interpleader proceedings.
Okay, what is an interpleader?
An interpleader is a procedure whereby a person in possession of property not belonging to him or her, or such person being claimed from such person by two or more persons, by which the matter can be brought to court for adjudication over a valid and completing claims over the property.
So does this mean now, let's say I have a housemate and the sheriff comes and he writes up his stuff, all the stuff that we share in the house. Now they take the TV, but the TV is mine. So do I now have to go to court to prove to them that that's my TV?
Yes, that's correct. Well, you must show that
I'm not going to be too happy.
To you, not the other person.
No, I'm not going to be too happy about that, to be honest. But anyway, I won't like the housemate anymore. When and who can use this interpleader process that you're talking about?
It can be used by any third party who is in possession of a property, and where the sheriff of the court attaches such property which belongs to the judgment debtor, in particular cases, and any person then claims that property that has been attached and say that it does not belong to the judgment debtor but to that particular person.
Okay, so how's an interpleader proceeding instituted?
It can be instituted by issuing a notice to the parties making the claims that an interpleader proceeding has been instituted.
Okay, and then what happens after that notice is issued?
So once the notice has been issued, the proceedings on any action which has been going on are now stayed and put on hold pending the outcome of the interpleader. Okay,
and lastly, what must be included in that interpleader notice?
Okay, so in terms of Uniform Rule 58, subsection 3, it says that an interpleader shall include the nature of the liability, the property or claim, which is the subject matter of the dispute. Secondly, it must call upon the claimants within the time stated in the notice, not being less than 15 days from the date of service, to deliver particulars of the claim. Thirdly, it must state that upon a further date, not also less than 15 days from the date specified in the notice for the delivery of particulars of claim, the applicant will apply to court for its decision as to his liability or the validity of the respective claim. And Rule 58, subsection 4 further states that there shall be delivered together with an interpleader notice an affidavit whereby the applicant states that he or she claims no interest in the subject matter in the dispute other than for the charges and the cost. And secondly, the applicant must state that he does not collude with any of the claimants. And lastly, applicant must state that he's willing to deal with or act in regard to the subject matter of the dispute as the court may direct.
Okay, so Olebogeng, just to quickly put it all together and sum it up, if the furniture is removed and that furniture is mine, or most of it is mine, or some of it is mine, I go into the interpleader process and it can take me weeks to get my own furniture back because I have to prove first that it's mine and go through all the hoops and even go to court. That sounds like quite a messy thing.
It's a really unpleasant experience, honestly, for let's say a third party whose particulars are being attached. I mean, nobody does not want to have their stuff getting attached and sold for something that they don't have any idea of. And yeah, it does take long for you to get back your furniture. Yep. And in some instances, if you fail to prove that those properties belong to you, then you might forfeit them.
No,
it's like that.
That's not good, man. That's not good. So should I keep all the slips to prove that it's mine when I buy something?
Definitely, you must give them, especially if you know that you have a housemate or a roommate.
Oh,
you
my
must
goodness.
keep everything.
My word. Okay, this has been very interesting because I honestly didn't expect that answer at the end of the story. But yeah, great stuff. Thank you for informing us, Olebogeng. Much appreciated as always.
It's a pleasure.
Thank you. Thanks so much.
Are you or your business in trouble and struggling to find a solution? Call Hahn and Hahn Attorneys as we assist clients in finding solutions. We specialize in consumer and food law, commercial and construction law, forensic investigations and administrative law. Visit hahnlaw.co.za. That's HAHN. We assist clients nationwide. Hahn and Hahn Attorneys, because we care. Don't miss Legal Talk with Hahn and Hahn Attorneys, Wednesday mornings at 10 on eRadio.